pledge, please. Tom, can you lead us the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Moment of silence for men and women in the armed forces, our first responders, our veterans, those fighting a good fight in Ukraine, and those suffering from military conflict in the Middle East. Also in memory of Frank Wargo and Pat McGuire. Thank you. Okay, Noreen.
Do I have any nominations for a moderator?
Move to Mayor Bass.
Second.
Okay. All in favor?
Aye.
Okay, motion carried.
Thank you, Noreen. Next, I'd like to read the warning for the special town meeting. This is a settlement of the case of Sean Henning versus the State of Connecticut, Town of New Milford. Pursuant to sections 901A and 903B of the New Milford Charter, the electors of the Town of New Milford and those qualified to vote in the town meetings are hereby warned and notified there will be a special town meeting held in the E. Paul Martin Room of the New Milford Town Hall, 10 Main Street, second floor, in the Town of New Milford on Tuesday, November 12th at 6 p.m. to consider, act as appropriate, and vote upon the following agenda item, and to decide by vote the following course of action and question. The agenda: 1, discussion of possible action and vote on whether to settle and fully end and discharge the $2.4 million a lawsuit titled Sean Henning versus the State of Connecticut and Town of New Milford, et al., docket number 3.20-CV-01792-JBA, pending the United States District Court against the Town of New Milford and 2 of its then police officers, which lawsuit seeks unlimited monetary damages for claim violation of Sean Henning's civil rights that resulted in his wrongful conviction and prison incarceration for 30 years. A question: shall the Town of New Milford appropriate and pay to Sean Henning the sum of $2.4 million in full, final, and complete settlement and discharge of the case of Sean Henning versus the State of Connecticut and Town of New Milford, et al., docket number 3.20-CV-01792-JBA, pending the United States District Court against the Town of New Milford and 2 of its then police officers, which funds are to be drawn from the town capital reserve account or such other account determined by the Director of Finance, and further authorize the mayor to execute such documents necessary or desirable to effect such settlement. Dated New Milford, this 5th day of November 2024. And we have here, we have our attorneys, Elliot and Randy. And Elliot, can you give, for those that are watching, can you give a brief overview of the case?
Sure, and I'd like to introduce Elliot Spector, who is our trial attorney in this case, who's been handling this case throughout. He was able to effectuate this resolution along with my facts.
Thank you, Mayor. Thank you, Randy. I put together a little chronological summary that led us here today. As you all know, on December 1st or December 2nd, Mr. Carr was brutally murdered. The police officers responded on the 2nd. The chief of police at the time recognized that she called the state police major crime squad. They came out on December 2nd. They took over the investigation, and they led the investigation the entire time that this case was investigated, over a period of about 3 years. On November 17th of 1988, the state police prepared an arrest warrant for Sean Henning. The matter that we're discussing does not include Mr. Birch because he has not agreed to settle, so I will just focus on Mr. Henning. On April 4th, 1989, the Henning trial commenced. It lasted until April 19th, 1989, and he was convicted. So, that was about 5 months after the arrest warrant. In 2019, the Connecticut Supreme Court ruled that Henning was entitled to a new trial based on the prosecutor's failure to correct misinformation with regard to the testimony of Dr. Lee with regard to whether or not there was blood tested on a particular towel that was at the crime scene. On July 10th, I should say, of 2020, the state's attorney decided not to retry Mr. Henning. At that point, of course, it was 30-some years later, actually approximately 30 and a half years later, and many of the people who would have been witnesses were deceased, and of course, it wouldn't have made sense to retry the case at that point. Well, following the dismissal of the case in July, there was a lawsuit filed against the state police, Dr. Lee, the town of New Milford, and 2 of its detectives. During the course of the litigation, we filed a motion to dismiss. What we do at that point is we take the 4 corners of the complaint and we say to the court, even accepting these facts as true, you still don't have a viable action. The court denied our motion to dismiss. We started discovery, and there's a tremendous amount of discovery in this case. And following the discovery, we filed what's called a summary judgment motion. When you do that, you can take the facts that have been gathered during the course of the discovery. And we again said, even taking this, which we have to do in a summary judgment from the plaintiff's perspective, and comparing the law, we don't believe that our officers committed any constitutional violations, and if they did, they're entitled to what's called qualified immunity. The judge denied our motion, finding that there were issues of fact. We went to the Second Circuit Court of Appeals. We said to the Second Circuit Court of Appeals, we will accept their facts. That's true. We still don't believe that they have a viable action, that our officers are entitled to qualified immunity. The court kind of kicked that issue and didn't really decide the issue of qualified immunity, but rather just said, well, the district court found issues of fact, and we do too. And so that brings us here today. And that's why we're at the eve of trial. And what always happens is the judges get you together and they want to try to settle the case. So on October 10th of this year, Mayor Bass and I spent 7 hours in federal court in mediation. It was unsuccessful. We couldn't come to terms. The judge in the case, Judge Richardson, did a fantastic job. At the end of the mediation, he came up with a figure that he thought the case should settle for, which was $2.5 million for each of the plaintiffs. Well, nothing happened. A few days later, I got a call from the judge that he received a call from Attorney Robb, who was Mr. Henning's attorney, and they were willing to settle for that amount. And essentially that brings us here, because they have agreed to it, and now it's the town's turn to decide whether or not you want to agree to $2.4 million. And I say $2.4 million because Kerma is contributing $100,000 to the settlement of the case. So the total settlement would be the judge's figure of $2.5 million. I would strongly recommend that the town agree to this, because $2.5 million, it seems like a lot of money. But when you consider that Mr. Henning was in prison for 30 years, and you never, ever, ever know what a jury's going to do. I mean, I can say right here today that I think we can win the case. I think we should win the case. If the other side was here, they would say the opposite, of course. The point is, should, could, is not would. Can't say for certain, and nobody ever could. And so this is a chance that the town has to avoid a risk that could happen in case a jury decides, well, we feel sorry for Mr. Henning, we feel badly for him because he spent 30 years in prison, and let's give him his due. Which raises the real question, what would that amount to? And we don't know. To avoid the uncertainty, Mr. Henning is taking this figure, and I would suggest that the town do the same thing.
Doug?
Mr. Spector, thank you for coming. Could you also elaborate on, I guess, the state had settled with them as well, right?
The state did settle, yes.
And what was the figure of the state settlement?
The total figure was $2.6 million. 25.6.
Right.
No. State. I thought it was 26.2. You said it's 25.6? Listen, it's more than $25 million in any event. And we we of course we have no idea what the plaintiffs actually got from that settlement. A lot of people think, well, that's what they settled for, and so they split that amount. But there's a tremendous amount, unfortunately, of attorney's fees and costs in litigating a case like this.
Just want to make it clear to people not only here but at home that this was also settled by the state as well. Like that they had a lawsuit against the state, the two gentlemen as well.
Absolutely.
And the state decided to settle.
And so essentially what we're doing, whether I'm exactly correct or Randy's exactly correct, it's about the same thing. It's about 10% of what the state settled for.
Okay.
Hey Randy, I know you had mentioned to the town council and then to the Board of Finance, both boards approved this settlement. Is for those that are watching, I hear it. Did the town have insurance back then?
Well, the town purported to have insurance back then. One of the policies that the town had entered into was with the Star Cooperative, which was a consortium of police chiefs all over the East Coast, actually, which got together and in order to avoid excessive premiums, created this consortium. Well, it turns out Star, if you will, risk-shifting group was never authorized to sell insurance in the state of Connecticut. They don't exist anymore. I don't know what their capitalization was. They insisted they had capital, but the reality is that it's not available. It doesn't exist. The reinsurer, the excess insurer, was a company named Lumberman's Mutual. Lumberman's doesn't kick in, of course, until the primary company pays, but that's moot because Lumberman's went bankrupt. It was a subsidiary of another company, and the last time to file a claim against Lumberman's was 2016, which is 4 years before this lawsuit was filed. I filed a claim anyway against Lumberman's, and as the mayor chuckled when I did it the second time, there's to no avail. There's no coverage, there's no assets to go after, there's no state insurance fund. Lumberman's still with Illinois company. So the fact is that, I think, in hindsight, doing that consortium was improvident, but nobody here did that. Nobody in authority for the last 30 years did that. But it was an attempt to save money by the then police department and director of finance, and it was to no avail. So there is no coverage. The reason Kermit is paying is because it's defense costs, essentially. That's what I would think LA would agree with that. They're throwing in what it costs to defend the case. They're defending the case based upon a reservation of rights. They assert that they had no coverage for these losses because they didn't insure at that time. But they are contributing toward the settlement, and they're paying attorney spector's fees in this. So I wholeheartedly recommend this, not because I know what a jury's going to do. If I knew that, I wouldn't be here. I'd be in Las Vegas predicting roulette. But the fact is that this avoids significant potential exposure. We don't know what a jury will do. We just don't. Every trial I've ever had, I've never predicted a verdict. So the reality is that it's my opinion and it's my position that it's in the best interest of the town to accept this settlement.
Thank you, Randy. Do we have, Katie?
I just want to confirm for people who may be watching and are just beginning to see this case and know about it, is that Dr. Lee, the state of Connecticut, and just about everybody else till they got down to New Milford has already been sued, right? Okay. And there's only one person left alive, is that right? Of the police that were involved? Of the officers that were involved when the crime occurred,
Yeah.
there's only one survives.
Only one survives.
Okay. And he,
Oh, yeah, he knows all about
Yes,
this. I met with him on Friday.
yes, right, so that's that.
So basically, it's $80,000 a year for this guy, the remuneration from us.
From us.
From us, for the last 30 years.
Right. That's a very good way to put it.
Anyone from the public that would like to address the town meeting?
Sure. All right, I'll do my due diligence. I have 4 questions for the attorneys, and my mind is basically already made up. But I have 4 questions just to get them on the record.
A lot of questions.
Mike Sonello, 111 Willow Springs, sorry. One, are there any comps that we could have to compare to the dollar amount? I'm sure there are a lot of cases that you guys have tried and have seen come up. Two, what are the consequences? What are the consequences of accepting the terms beyond, of course, the expenditure, such as is this going to be effectively dismissed with or without prejudice? As in, can they bring a similar case up ever again? And then there were two questions about the actual claims that were being made that were in dispute. If we could just say very briefly what the factual claims are that are in dispute, potentially, and what the legal claims are that are in dispute. That's all I have. Thank you.
Ellen?
With regard to the question, is this going to raise its head again, its ugly head again? The answer is no. There's a complete and full release without any admission of wrongdoing. The factual claims in this case against the New Milford police officers are that one of the detectives allegedly was with a state police detective who allegedly led a witness that they're considering to be a fabrication of evidence. That witness actually said Mr. Birch confessed, and he later recanted that. So that's a question of fact as to whether or not that happened. The other issue is with regard to another detective here. Well, it's Steve Jordan is the other detective. And I do want to correct something for the record that is very, very important, because the news media reported that Detective Jordan found $1,000 at the crime scene. And it was reported twice by the news media that he found this and he did not turn it over to the prosecutor's office. That is not even claimed by the plaintiffs. There's not a scintilla of evidence with regard to who found $1,000 or where it was found. What is admitted, and there's no question about this, is that Detective Graham from the state police on December 4th, which is 2 days after the police officers arrived at the scene of the crime, that he gave this bank envelope and money to Detective Jordan and instructed him to return it to the victim's daughter, Diane Colombo. And so Detective Jordan did that. He documented on a return receipt that he gave the money to her and put it in the police file. So their claim is that he withheld exculpatory information. And our argument is, well, he did not, because that's the true story. So those are the claims that are involved. Now, would you please remind me about your other two questions?
To get to the dollar amount, were there comps? And the final one was, you talked about the factual claims that are in dispute. What are the legal claims that are in dispute?
Okay, the legal claim that's in dispute is with regard to whether or not the $1,000 actually amounts to exculpatory evidence. We're claiming it does not. The other side is claiming, well, the whole theory of the case was a burglary gone bad, and no burglar would leave $1,000 behind. And our position on that is, well, this was a logical theory in this case, and the burglar would not have found it if the police officers didn't find it until well after they arrived at the scene, searched the scene, photographed and filmed the scene. It's certainly some burglar who committed a murder like this would not hang around to do a detailed examination of the house. So that's one of the questions that's in the case. With regard to the fabrication of evidence, Mr. Kochia is the one that called the police officers down to Norfolk, Virginia, where they took the statement. And there was absolutely no coercion during the course of this questioning. There were some facts that were provided to him, but they were not such facts that would cause him to give the confession information that he gave. With regard to comparables, it's very difficult. It's all over the place. And I can tell you that for approximately the past 10 years, a lot of attorneys have used as a rule of thumb, if somebody is wrongfully incarcerated, well, what's it worth to spend a year in prison? $1 million a year. So that's the best that we have.
Yep. I could address one of the issues, yes, consequences. Mike, you asked about consequences of the settlement. Yes. Mayor Bass, Vice Chair Francis, Director of Finance, Melvin Coffin, and I have met on this, and we've examined it. The auditors know all about this case. And in fact, they've known about it every year, because I've told them about it every year since the case was filed. It has not had any deleterious effect on our bond rating. As a matter of fact, at all. Now, consultation with bond counsel and our investment counsel, Mr. Bernardi, made a determination that this could be paid out of our accounts. So that's a consequence that's obviously a consequence, it's material, but it's not going to have an adverse consequence. So you know that.
And Randy, approved by the town council
And approved by the town council and
Board of
recommended
Finance.
unanimously by the Board of Finance.
Any other questions for the attorneys?
I have.
Sal?
So I guess to the attorneys, how many cases in Connecticut do we have with a precedence like this, that someone went to jail anywhere from 20 to 30 years, get out of the jail, and they say there is a retrial, and then there was something found, and they're being rewarded with the money. So if there is a 1 case, 2 cases, 3 cases, how many of them failed? How many of them succeeded as a precedence?
I know there are cases.
I would venture to say, given my history dealing with this area of the law, that we probably have one of these wrongful conviction cases maybe every year. And the wrongful conviction cases are usually fairly significant cases. This is the longest wrongful conviction case in the history of Connecticut, ever.
So we have no precedence that we can compare
No,
to this.
there's one pending down in New Haven now, which is 17 years for one of the defendants in the case and 19 years for the other one. But this one is 30 for each. So this is the biggest one ever. And this is actually the biggest potential damage case that I know of in the history of Connecticut. And I've been doing this for 40 years.
So there is no law, there is no precedence yet, right?
Well, precedents, I mean, every case is different. You know, there are different cases that settle for different amounts of money, given the strength of the liability of the case, and the personalities of the people involved. I mean, I think that's one of the reasons that this case is not settled in full with Mr. Birch, is probably because of his beliefs and his personality are different than Mr. Henry.
So I have one more question. So how many, was Mr. Henning ever convicted of anything prior to this trial that he went to jail for 30 years?
Both Mr. Henning and Mr. Birch had prior convictions and had spent time in correctional facilities, yes.
So they were convicted felons.
And that's one of the reasons that they were identified as being potential suspects, because they were committing burglaries and they had used, you know, some narcotics, recreational narcotics, and they stole a car in addition to the burglary that they were accused of in this case. They did steal a car, so they're having convictions for both of them. They were a couple of young kids that unfortunately dropped out of high school and needed some money, and they committed burglaries and they stole stereos and things like that. They had a fence in Danbury and they sold and they got nominal money, but it was enough for them to live on.
So there was a precedence that they committed a crime before.
They, you know, they were criminals as young people, and you know, would they have continued to commit crimes? Who can say?
Yeah, how come the newspaper is not saying anything about that? Well,
You have to ask questions.
I don't have more questions.
If we had control of the press, you know,
Yeah.
it might be a wholly different story. But, and that's one of the reasons why I thought it was important to correct the false statement recently made in the Danbury Times and the other Hearst publication.
I agree with you.
Thank you for the clarification.
Any other questions for Randy or Ellen? I'd like to entertain a motion to answer in the affirmative for question 1. Shall the town of New Milford appropriate and pay to Sean Henning a sum of $2.4 million in full, final and complete settlement and discharge of the case of Sean Henning versus the state of Connecticut and the town of New Milford et al., docket number 3.20-CV-01792-JBA, pending United States District Court against the town of New Milford and 2 of its then police officers, which funds are to be drawn from the town capital reserve account or such other account determined by the Director of Finance, and further authorize the mayor to execute such documents necessary or desirable to effect such settlement.
So moved.
Do I have a second? And a second. Any discussion on the motion? And for the town meeting, all in favor, signify by saying aye.
Aye.
Any opposed? Any abstentions? Please note one abstention. I'd like to entertain a motion to close this public hearing.
So moved.
Second.
Second.
All in favor?
Aye.
Opposed? Abstentions. Thank you, everyone.
Thank you, gentlemen.
Our next